I'm looking for a police job. I think I could tell.
I got it.
Yeah, right. Get my yardstick in.
Good afternoon. I'd like to call this meeting to order, please. It's the Salina City Planning Commission. So we'd like to start. If everyone would like to have a seat, please. First item on our agenda tonight is approval of the summary minutes of our June 6th meeting.
So moved.
Second?
It's been moved and seconded to approve those minutes. Any discussion? If not, all those in favor vote aye, please.
Aye.
Any opposed? Motion carries. And our first public hearing item is application CU 11-7B filed by Iron Street Tattoo, requesting amendment of the amended conditional use permit, which allowed a tattoo parlor, body piercing studio to be established in the C4 district at 111 and 113 East Iron Avenue.
Thank you, Mr. Chairman. Staff would request that this particular item be moved to the end to allow for the applicant to receive a phone notification, because it appears they are not present and we can't meet on the topic without their presence. So if it would be the will of the board, we would request that that get moved back and the next item be the item that we look at.
Any problems?
I would so move.
It's been moved and seconded to move that agenda item to the end of tonight's proceedings. All those in favor?
Aye.
Any opposed? It's been moved. So we will begin tonight with application 3-2, which is application Z17-5 filed by the Salina City Planning Commission, requesting a review and amendment of Article 7 of the Salina zoning ordinance, rezoning to a planned commercial district.
So we're trying to locate the applicants for item 3.1 so that we can get them for today's meeting. On item 3.2, this is a text amendment of general application. It was advertised in the newspaper according to the statute, but we'll preface with a couple remarks. We sent this draft out to design professionals and representatives of the development community. Their feedback was that we didn't give them enough lead time, so that we will preface this by saying that this is an open public hearing, but we're going to recommend at the close of it that it be continued to your July 18th meeting. The other aspect of this is, although we focused on addressing many of the concerns that the Planning Commission and City Commission expressed, we've got other members in the development community who are interested in this, and property owners and others as well. So the approach that we're going to take today is to give you an overview, get your feedback and critiques, and then we will recommend that it be carried over. And then at the close of today's meeting, we're going to discuss with you what is going to be our new process for zoning text amendments, because we're finding that we need to have an alternative to have open discussion with the Planning Commission at a meeting and get input from the public without making that the formal statutory public hearing. So what we've indicated and discussed with you in the study session was I started work with the City of Salina on March 1st, 1987, and one of my first tasks was to help create a planned commercial district process, and so that was initiated in June of 1987, and we discussed that as a planning technique that could be an alternative to planned development districts, but while also assuring that what is shown on a site plan is what is actually built, and giving the Planning Commission and governing body some influence on the form that development took in appropriate conditions of approval. So it is kind of what could be considered a planned development district light, and in some cases it's been used for single use on a single tract, such as the redeveloped Quick Shop at Crawford and Centennial, and it's also been used in a multi-lot commercial center, such as Auburndale, the site of Lowe's, or Magnolia Commons, the site of Menards. And so what we're showing here, and you may need to slide it down a little bit, John. Oh, okay. To show more of the top. I guess it's cut off. So what it's trying to show in this case is that this is a multi-lot commercial development. There's 3 development lots. When this came before the Planning Commission for a public hearing, what came before you was a specific plan for the Menards lot, but with deferred site plans. There were no identified users or plans for the other lots, but we did have this arrangement. And so this was done as a planned commercial district with a deferral of the site plans on the outlots. And so the process is that it is treated just as a regular zoning case. There's a zoning ordinance that gets adopted that rezones the property in cases where commercial lots we don't have known uses at the time. That site development plan has been deferred at the request of the then city commission at that time. They used the individual ordinances to delegate the authority to review site plans to the Planning Commission. And so there's been one amendment that's been made since 1987, and that is an amendment that clarified the distinction for permitted and conditional uses and the ability to add those to a planned district, and that was approved in 2015, and carried over into 2016. So there have been no changes since that time, but we had a request recently to rezone an R2 zone lot on South Ohio Street. The request was for straight C5 zoning, and at your initial public hearing, you requested that be converted to a planned commercial district so that you could have an opportunity to review the site plan. So you directed that the application be amended. The applicant initially agreed to submit a site plan. It turned out what they had didn't meet all the requirements for a site plan. You recommended Plan C5 zoning. The City Commission ultimately approved Plan C3 zoning with a requirement that the final site plan be approved by the governing body before any development occurred on the property. Both you and the City Commission expressed dissatisfaction with the current ordinance and the process that was followed, so we initiated a text amendment, discussed that with you, had a study session to get some direction and feedback, and the goals that we tried to address based on your feedback were, first, clarifying when planned commercial districts are required; second, clarifying what needs to be submitted with an application; third, specifically allowing for the deferral of site development plan submittals; fourth, allowing for the delegation of site development plan review to the Planning Commission; and fifthly, clarifying that when an ordinance rezoning a property is approved, even if there might not be approved site plans for all the parcels, that it would show as a commercial property. As we overview the draft, I guess, have we been on this slide the whole time, John? All right, so this was the overall plan. If you could can you go to slide 2? So this was the more detailed plan, the very specific plan for Menards that you approved as part. This is a Plan C5 district, and you approved this site plan as part of the rezoning case. If you could go to number 3, John. That's the overall layout for the Auburndale edition, but if you could go to number 4. So when the application was submitted to rezone the southeast corner of 9th and Schilling, the only known and identified user at that time was Lowe's Home Improvement Center. And so what you got was a detailed site plan for Lowe's and then a conceptual site plan for how the other sites would develop with deferred site plan approval there. So now if you could go to the text, John. So to just kind of give you a summary, the biggest policy change and the reason for why we are recommending that this hearing be continued is because it is a big change, but there's been much discussion about neighborhood centers. There's been much discussion about how we move development closer to the comprehensive plan, but not everybody in the community shares that as a goal or value. And we were concerned when we were talking about neighborhood centers versus other commercial areas that if we weren't careful, we would steer people away from the neighborhood centers towards locations that didn't have those requirements. So taking all those things into account, the draft that is before you would require under number 2 that anytime you are rezoning from a non-commercial zoning to a commercial zoning, that would be done through a planned district, and that if you had a existing commercial zone and you were going to another zone of commercial classification, then that would be done through a planned district. And so that is a big policy change, but the alternative to that was to try to either make it very discretionary, which just allowed you or staff or someone to decide when was something done as planned versus unplanned, and then we risked the possibility of treating similar situations differently. So the idea is that under this process there would be no more straight commercial zoning. And so the that is point 1 in terms of when is that required. So I guess we'll pause here because we may not have the right item on the screen for you.
Dean, while we're paused here, what you've described is not a departure from the packet. I mean, that's what we have in the packet.
Nothing here is a departure from the packet.
Yeah. Yeah, I was just looking at some of the changes underlined in red here are just in straight text.
Right.
But that's the only change I see in the page.
So
that
I don't.
helps.
So we'll defer to Mr. Bankston whether we made the right choice or the wrong choice. On the red line versus the non-red line version, what you would prefer that we display?
Yes, thank you, Greg Binkson, legal counsel for the city. And I apologize for waltzing in. I was in another meeting and wanted to be here for this item and just happened to notice that the red line was up. And I thought that the final version that was distributed on Friday would have been with those changes having been accepted and just distributed without the red line.
That's what they have in their packets. So that was an error on our part, or what we gave to Mr. Berger, so we can pause here and rectify that.
Yeah, it was just that those were some final revisions, but they are not red lines in relation to what I understood that was distributed to you all. So
Right.
No, it is not.
Right.
that was the only thing I was fearful might be confusing when in fact,
This is not the right one.
Well, this is interesting. So, we have a black and white one.
right.
Right.
yes, I
Which is what you
understand.
want us to have.
I suppose we could make a
Yeah.
quick check if.
Okay.
if,
Okay.
I just want to clarify that for better or for worse, Mr. Hers decided that you as a planning commission like to see red lines. So we had two versions. The one in your packet has no red lines. All the most recent changes were accepted, and it's a clean version, and that's what's in your packet. We have erroneously put up on the screen to walk you through the red line version, and we will pause and attempt to rectify that.
Thank you.
Sounds fine to me.
Thank you, Mr. Bankston. And I see our applicant for item one
Disregard
is
the red
here.
line version.
Well, you don't have the red line version.
No,
It's
but
not, it's not in your packets. We are displaying the wrong
Yeah,
version on the screen as we attempt to walk you through it, so.
right.
Anything that was redlined in that red line version would just have been shown as part of the text on the version that was distributed to you all,
Right,
if that makes sense.
right.
Thank you.
I was concerned that the red line might appear as though they were changes from what you had received, when in fact, they are not.
Yep. I checked out the first line, and that checks.
Thank you.
So we really don't need a graphic to proceed then?
No, we don't.
No, we're
We
fine.
don't.
You have it in your packets. You don't need a graphic to proceed. You have it in your packets, and what you have is the public hearing draft, and what we're going over is what is in your packet. We just made the wrong decision as to what we were going to display on the screen for you.
Yep.
So, in this draft, staff is, well, I'll pause, and we'll make sure that we're... The versions are identical, it's just one has red lines in it and one does not. But, so we'll go back to the big change, and the big change, if you look at what's numbered as number 2, what that says is essentially is that there's no more rezoning property to a straight commercial zoning designation. You can only apply for planned commercial zoning in the future. And so what we tried to explain to you was that if you look at the corner of Ohio and Crawford, and some of those sites have redeveloped, McDonald's had a redevelopment, Subway was a redevelopment, CVS Pharmacy is a redevelopment. And your question to staff was, how do you get new development to move closer to what the comprehensive plan is recommending? If you have straight C5 zoning, all you need to do is submit a building permit, and if your plans conform with C5 zoning, you can get a building permit, and the comprehensive plan is not even looked at or applied to that building permit. So what this would do, it would require that all planned commercial or all requests be a planned commercial request. That would allow you to adopt in your review using the criteria in the comprehensive plan to review the proposed development. So that is item 2, and that is the big policy change from presently it is we have some requests that have been done through straight commercial zoning, some have been done through planned commercial zoning. It's usually a function of if it's in a sensitive area, or if it's next to residential, or if it's in a sensitive gateway into the community. The Planning Commission has leaned towards planned commercial for those. But in this proposal, there would be no discretion. Everything would be planned commercial. But that's a big change, and it's a big change for design professionals and others who are used to doing everything through the building permit process and not through site plans that are reviewed by the Planning Commission and governing body.
So, Dean, maybe clarification is not necessary, but is from your remarks at the beginning, is our understanding then that some of the people who have concerns about it and feel like this is too rapid a transition, were they unable to be here and comment
For the
on it
most
this time?
part, they were unable to be here, and they felt like they wanted additional time to review the draft
I see.
and to provide their feedback. But the consensus of what we got, people received the notice, they received the draft, they understood what was being proposed, but they thought particular item 1, that policy change needed longer to digest than just this public hearing.
Okay.
So the other change would be essentially it's giving the applicants a menu. So John, if you could, you've gone a little too far. If you could go up to number 4. So one of your concerns and staff's concern was to have some clarity as to what needs to be submitted and what process we're operating under. So under A, we have a single lot. So let's look at number A and number 1. In the case of Quick Shop at Crawford and Centennial, we knew that it was going to be a quick shop. They had developed their plans. We identified from their plans that they had some things that didn't conform with the standard C5 requirements. And so what they did was they applied to rezone that property from residential and C5 and unzoned former right-of-way to Plan C5, and they submitted a site plan that was reviewed concurrently with their zoning request. Under option 2, that is the approach that was used in the case of the South Ohio rezoning that was done earlier this year, and that is that the applicant could request consideration of the rezoning and ask that the review of the site plan be done on a deferred basis separately. So you would be evaluating whether that should be zoned commercial, and if so, what designation, allowing what uses, and then understanding that a site development plan would come back to you at a later meeting before any development occurred. The same thing could occur under option B. Option B is the examples of Magnolia Commons and Menards, or Auburndale with Lowe's, that it's given to the applicant that they can request simultaneous consideration of the zoning and site plan, or they can request that the zoning be acted on and deferral of the site plan come in. So we had, I'm trying to think of our most recent example. Well, we talked about that in the case of Chick-fil-A. The zoning for Central Mall was approved and finalized in 1986. And in 2016, we got a plan to develop one of the outlots. So as we try to describe the process from our perspective, is that when the zoning is applied for, that is the time that all the basic parameters, whether it's building height limits or sign limitations or landscaping or limitations on uses, all those parameters are established when the property's zoned. And then if there's a deferred site plan, then the details of how the site's actually arranged and developed and what's the building location and height and where it's located, that is part of the site plan. And so I can't remember if it's here. Yeah, it's, if you read the introductory paragraph, what it tries to make clear is that the planned commercial zoning process and consideration for approval of a site development plan they're mutually dependent, but they're distinct processes. So there may be different things that you look at when you're considering the zoning land use question than you would if you were looking at an actual site plan. So what we're saying is it can be done concurrently and work, and it can also be done on a deferred basis and still work. But the one thing that is uniform is that no development occurs until the Planning Commission and City Commission approve the site plan. And again, that would be a change from the standpoint that there have been situations where somebody takes a lot, rezones it to a straight commercial designation, a building permit is issued, and you get to see the end result, but you don't get to see the site plan before the development occurs. So that would codify that nonetheless, you still have the discretion if you think that things are too uncertain or the fact that you don't have a site plan bothers you because it's next to a residential area or it's in a sensitive area, you always have the discretion to deny the commercial rezoning if you don't feel comfortable with that property being zoned commercial. So you can...
At the time of the rezoning.
Right. An applicant can bring in an application and he says, I don't know what my use is. I just want you to rezone this commercial. If you don't feel like you have the right information to make the zoning change, you still have the discretion to turn the zoning application down.
Well, one point that's made in the packet, at the bottom of page 4, top of page 5, in the comments before, is that a key policy question is whether full notice and separate public hearing should be required for action on a deferred site plan. And so the site plan is deferred, it comes in later on. Should that come before the commission? And I know we're not taking action, but just as one commissioner, I think that would seem to be a wise thing to do. And seems like that's consistent with the policies we've had, is to look at the site plan before, even if it's deferred. If I understand that question.
Well, I will just point to today's agenda where you can see that under administrative items we have a site development plan for you, and that is not a public hearing item, and it wasn't advertised as if it were a zoning change. And so the draft that we have in front of you as it is drafted would require that if there is a deferral of the site plan, that notice and a public hearing be held on that plan and that it no longer be an administrative matter. So just to make clear, even though we're saying that's a policy question, the draft that is before you would require notice. And so what we're saying is that if you look at today's agenda, you have administrative items. 4.1 is a site plan. If this draft is adopted as proposed, then those would not appear on your agenda as administrative items. Those would appear as public hearing items, and we would send notice and the site plan out to neighboring property owners, and they would have an opportunity to come at a public hearing and comment on the plan. And we think that's only fair if they come to the hearing and they have a whole bunch of questions about how close the building's going to be or where the driveways are or what's proposed for landscaping and screening. And we say, well, we can't really answer that till we get an actual site plan. It is fair to give them an opportunity to review and comment on the site plan as if it were submitted simultaneously. So that, in other words, if an applicant has a request for simultaneous zoning and site plan approval, the neighbors are getting a chance to review that site plan and comment on it to you. And if we don't make that same requirement for deferred submittals, then we're kind of treating the neighbors unequally. So the proposal is that all deferred site plans would be done through notice and a hearing process. It would be a public hearing item. And then the other thing that we were trying to address is to make clear that if there's action taken by the governing body to approve planned C5 zoning for a tract, that's going to appear on the official zoning map as Plan C5, so the developer can market it, or a realtor can market it as such, but there will be a note that states that no development can occur on any lot till the site development plan has been approved by the Planning Commission or City Commission, whichever the case may be. And then
I think that's a very good plan, and I think we had a kind of a consensus when we talked about the South Ohio property. I may be wrong. I may be misreading.
Well, these are points we've made repeatedly, actually, on several processes, and it seems to include basically everything that we've questioned or asked about. Are we forgetting things, or are there things you
we're
omitted
not,
that
but
we asked for?
Where staff dropped the ball was that we were viewing you as our audience, but we have the whole community, the whole development community, design professionals, engineers are also our audience, and we didn't give them sufficient time to digest these proposed changes. So you are one of our audiences, and you are the applicant, so we made it a point to try to address those things, but this needs further public comment and vetting. So what we did attach in your packet was the text of the current ordinance. One of the things we had in your packet that's highlighted in yellow that you don't get to see, but highlighted in yellow after this draft is just a sample of when your work is done and you make a recommendation and it goes to the City Commission, it is turned into an ordinance that rezones the property. And so usually that's done with conditions of approval. And in the sample we gave you, it says final site development plan and final landscape plan for each individual building site in Magnolia Commons shall be approved by the Planning Commission prior to issuance of any building permits for these sites. So if you recall, I can't remember the exact date, but you did review a final site development plan for a Fairfield Inn motel in the Magnolia Commons addition, which is north of Menards. So that is an example of how that deferred site plan review has occurred, was that this ordinance number 08-10476 rezoned Magnolia Commons. It set out all the development parameters, and then it allowed the developer to defer submitting site plans till they had identified users for those other lots. And we're proposing to continue that, but we think the draft ordinance does a better job of spelling that out. And then I would also bring your attention to that you would want to study for future reference is the deferred application for approval, which is under item 17, John. And under item 17 there, subpoint 2, as it relates to your comment, and Mr. Norland, was that the plan as proposed here is that in the case of, say, the Fairfield Inn, which was done out there, Menards, instead of that being an administrative item, we would do a notice and a full public hearing on that site plan at the time that it's submitted on a deferred basis. So under 17, number 2 says that we will schedule a public hearing the same as we would as the initial rezoning of the property. And then I wanted to point out to you that under 3, that addresses the process for when you are responsible for review and approval of the site plan, which you will approve or disapprove. If the Board of Commissioners reserves that responsibility for review to themselves, then what you would be doing is that you would be acting in a recommending capacity like you do on a zoning case. So what this does, and I'll let Mr. Bankston tell me if I've misspoke, but it creates a presumption that the Planning Commission will be the final reviewing authority, but allows the City Commission, if they choose, to reserve that authority unto themselves. And then, under 5, if there's a situation where you were the final decision maker and someone was not pleased with your decision, then under number 5, you could have your decision appealed. Actually, it goes to number 18 there. If an applicant is dissatisfied with your decision and you're responsible for the review, that gives the applicant the opportunity to appeal that to the Board of City Commissioners.
Any other questions?
So I guess our primary focus today is that we have focused on those items. Did we adequately clarify for you when planned commercial districts are required? Have we adequately, in your opinion, clarified the application submittal requirements? Have we adequately allowed for deferral of site development plans, and do you want to do that? Do you understand the language that essentially creates the presumption that you will be doing the final reviews, but that if the City Commission reserves that to themselves, then you'd be in a advisory capacity? So there's not a process by which you would not review a site plan, but in some cases you would be the final decision maker. In some cases you would be making a recommendation to the governing body, and that's going to depend on whether the governing body has reserved final review to themselves. And then, have we made it sufficiently clear that when an ordinance is adopted changing the zoning to planned commercial designation, the map is going to reflect that as a commercial designated lot?
So, Dean, this is the language in number 4, I think, that you're talking about in subsection 17. And I guess my question is, if the Board of Commissioners reserves responsibility for review and approval of that site development plan, is that something that they do in advance of the Planning Commission?
Yes, it's done in the ordinance. Well, that's in the case of a deferral. So
Okay.
I have given you, if you, in your packet.
Yeah, so the line.
In your packet, you will see section 4 in the ordinance that says a final site development plan, final landscape plan for individual building sites shall be approved by the Planning Commission. That's in the ordinance rezoning the property. If in the ordinance rezoning the property, the City Commission reserves that to themselves, it's going to be addressed in the ordinance that actually rezones the property.
Got it.
So you won't know, in the case of where you don't have a site plan, you won't know necessarily till we tell you whether you're acting in a advisory capacity or a final decision-making capacity. So I will give you the example, the ordinance that rezoned the lot on South Ohio to planned C3. That ordinance reserved to the City Commission the final decision-making on that site plan. So it will come to you, but you will be recommending to the City Commission whether it should be approved or not approved or subject to what revisions or conditions, but you will be acting the same capacity you do when you're recommending on a zoning case. And so we will tell you in our report whether you're the final decision maker or a recommender, but you won't necessarily know until the ordinance is adopted that rezones the property.
So the commission makes that decision on a property-by-property basis, case-by-case basis?
Correct. And they could
And what are their
decide,
criteria? Can you explain what's operating there? I don't.
their criteria is that they're the governing body and they get to decide. And so
Oh,
Which is
The-
why we're doing this.
there's not going to be any criteria for that. All I can describe it is that when the planned commercial district was first executed, and the very first one, I believe, was the Walmart site, which is on your agenda today, which was done in 1989. And the city commission said, well, can't we just delegate the site plan reviews to the planning commission, because that's what we have a planning commission for. That's how that particular governing body felt at that particular time. But what this does is reserves the authority to the governing body that they have. And so if there's a rezoning case and there's a deferred site plan, when that goes before the governing body to adopt an ordinance to establish that district, they will decide at that time whether they wish to delegate those final decisions to you or reserve those unto themselves.
And in this
So
example, the zoning change would already have been made. This is a deferred later.
that's a deferred site plan. So I'm going to pause and look over to Mr. Bankston and see if I have correctly described the way that that is set up. And particularly this section, John, which I think is under sub 17.
Thank you, and I believe you have, but just to quickly make sure we're all on the same page, in the case of the simultaneous rezoning application and consideration of the site plan, in those scenarios, this body, of course, would see both, presumably at the same time, make your recommendation to the governing body. They would be looking at both, and they would act on the ordinance and on the site plan. The only time we get into this question we've just been discussing is if you go through the zoning process where you all will make your advisory recommendation. The governing body ultimately asks or acts, and we know that there is anticipated a deferred site plan. In that case, your point is a very good one about the criteria, and frankly, at this stage of the process, we probably would have been a little bit presumptuous this has not been discussed with the governing body. So either we will be watchful to make sure that if for some reason they wish to reserve that ultimate review, that we would document why it was that they made that choice in the ordinance. If there are consistent criteria that they know that they want to apply, then we'll probably want to go ahead and articulate those in the ordinance. But the thought being that you've got some lapse in time, you would have, when the ordinance adopting the rezoning is approved, that is when the city commission has to make that call. It's not later when the site plan application begins. It is at the stage where they are acting on the zoning ordinance. That would be the time that they would say, for such and such reasons, we believe we should reserve that review and approval. If they do not, the presumption is that that is on a deferred site plan left to the Planning Commission to review and approve.
I have a question. For instance, like the developer didn't want to prepare any site plans because of the expense and wanted to know that the zoning was going to go, be allowed. Well, So then they were zoned and the site plan was deferred. All right, what if that deal falls through? Is that still then a planned commercial zone?
John, if you go, and it's better worded here than what we have currently, but basically, if they don't act on that, they don't do something under that, then there's going to be a revocation of the zoning, and it would just revert back to what it was before. If the deal falls through, if there's nothing there.
There's some
That's in number
time period.
19.
Yeah, that deals with the,
Well, I think that's
that
strictly,
deals with the site, the validity of the site plan.
yeah, that's strictly with the status, in relation to the status of the site plan. As presently drawn,
The zoning
the
would
zoning
stay.
would remain in place. The concept is, and it is an outgrowth of this matter of the relationship between the plan zoning and the site plan review. And that's what prompts trying to look at this as two dependent but separate processes. The concept is that the zoning question is one question, the site plan is another. That's why, if you have an approved site plan and it's not acted on in that period of time, the site plan goes away, but the zoning doesn't, and it would still be necessary to come back and get approval of a new site plan before anybody pulls a building permit. There would always have to be an approved site plan.
And that would
Is
be
the
the
concept.
advantage of requiring the new notice and public hearing, that if something happened
Right.
and something new came along, then the neighbors would have an opportunity to know that instead of it
Exactly.
being.
Yeah.
So Greg, again, to make sure that we're on the right page, and I want to repeat what I think I heard you say, if the Board of Commissioners, the City Commission itself, when they approve a zoning, approve the ordinance, then are you saying that any deferred site plan, if they designate that it should come to them first, comes to them first?
Well, they reserve the ultimate approval.
In any case?
No, I'm sorry, if you've got a deferred site plan,
Yes.
your zoning has been dealt with,
Right.
deferred site plan, the presumption is that there would be a public hearing and that this body would review and ultimately decide whether that site plan was approved or not. That would be the end of that process, unless the applicant was dissatisfied with the decision and appeals it to the City
Right.
Commission. The only other scenario would be potentially if, for whatever reason, the City Commission, in that it's their authority that we're talking about here
Right.
and being delegated, the presumption is the delegation, the exception is if they, for whatever reason they believe to be appropriate, decide to reserve that final review, it would still go back through the process. You all would hear it, and in that case, it's almost a repeat as though it were the original process where it comes before this body, and in that case, you're in a recommending role with the City Commission then exercising its reserve right for final approval.
Okay.
All the same
So I want
things.
to be sure I understand that. But that decision that they might make to have it come back to the governing body after review here, are you saying that that has to be made at the time of the zoning ordinance
Right.
approval? At that time, not at any
This
other time?
anticipates that they would make that decision at the time that the rezoning ordinance would be acted upon. Now, as I stand here, if they said 2 months later, we've changed our mind on that,
Yeah.
And that's very possibly a point of clarification that
Yeah.
possibly should be made. I would expect that they might wish to reserve that. I mean, it is their authority that is being delegated.
Yeah,
So
since they are the elected body, they would
Yeah.
have that power in any
Yeah.
case.
it's a good point, and
Yeah.
that very well may be something that we could clarify one step further, is that they don't waive that right.
Yes.
If they don't exercise
But-
it at that moment in time.
Yeah, but the recommended proposal here is that they do it at the time of
Yeah,
the
the
zoning.
thought is that if they wish to reserve it,
Yeah,
that would be the thought.
that's helpful. Thank you.
So, the other thing, if I may, Mr. Chairman, just a quick point, and in my role in assisting with the drafting, we certainly had the direction that you all had given. And on the first question of, when is the planned zoning required? The first person, I want to make clear, it was not planning staff that said, well, okay, we can answer that one. Let's just make it whenever you're transitioning to a commercial zone. It was more an outgrowth of my raising the question in trying to address not the policy issue, but the legal dilemma that I believe we find ourselves in sometime, and that is it a planned district or is it a straight commercial zone that you're transitioning to, and when and how is that decided? So I simply raised the question of, if in Salina, Kansas, are we to the point where, in attempting to implement the comprehensive plan and to deal with this question on as predictable a basis as possible, are we to the point where anytime you're transitioning either within commercial zones to a higher density or from another zone to a commercial zone, does this work best if we are consistently and predictably in a planned context? I don't know the answer to that question. My thought from a policy standpoint is absolutely irrelevant. I just knew from a legal standpoint it was a solution, possibly an overly simplistic solution, but it was a solution to the legal question of how do we address if and when you're looking at a straight zone or a planned commercial zone. So I hope that's helpful as you deliberate on this draft. As I say, that approach was attempting to address a legal question. The question that you all posed I realize there's a lot of policy content in that question, but there's also a legal aspect that I was trying to address, and that is on that question of which is it, and are we to the point where the planned commercial is going to be consistently the answer, then this is one approach. If there are properties out there where this body and the governing body say, no, we believe there is still circumstances where the transition to a straight zone works and works well, and somehow we get to the comprehensive plan via that mechanism, then it's a little harder, but we would address that as best we can, drafting from a policy standpoint. But the point was that this solution was born out of a discussion of how to address the legal question of is there still utility in a transition to a straight zone, or are we to the point where a transition to a plan is always going to be the better approach?
Thank you very much, Mr. Banks, and it's well written and precise. Other questions? Comments?
I just wanted to call your attention to one other thing as a homework item, given that we're going to continue this hearing. And number 14 in your draft there, I think we could perhaps do better than that, and perhaps that those development standards or criteria could be expanded upon, but the one that you expressed the most concern about was evaluating site plans based on the development criteria and the comprehensive plan that we went over with you, but obviously conforming with the zoning district requirements would be an important criteria as well. But if you look at number 14 and you think that the criteria that you want to apply to your review of a site development plan, if that list should be more expansive, then that's something for you to think about. But I do want to just state from the planning staff's perspective that we think that the draft that you are reviewing here, from as we outlined what your goals were and what planning staff's goals were, that the draft that's before you is comprehensive, it's understandable, it touches all the bases, and from that standpoint, it's good. That being said, we have design professionals and members of the development community that want additional time to review and digest and comment on that. So of the alternatives that we identified for you, we did give you the alternative of the postponement and continue the public hearing. What would be helpful is if there was anything particular in this draft or things that you thought we missed or needed to be clarified, if you would make that as part of your motion to postpone to July 18th, that would certainly help us. If there's things that you would like to see clarified or expanded upon, or if not, then we think the appropriate action today would be to postpone consideration of this application to your July 18th meeting to allow for additional public input.
This is a public hearing. Is there anyone from the public that wants to speak on this? Gentlemen? No? And are there particular recommendations that we should be making in terms of review or final review?
I have brought up in the past that if we wanted to develop, say, a service station or convenience store, that the pumps would be located behind the building. And I never felt a consensus, but would this be the time to put those kind of design parameters into the ordinance, or?
I think by establishing this ordinance, we would have the ability to make those sorts of determinations in the future in the planning process. Without this ordinance, we wouldn't have that.
So one of our jobs is in our staff reports and our reviews is that one of the is that to try to move commercial development is to being more pedestrian oriented. If there's a belief that having the building push forward and gas pumps or other things to the back is what makes something more pedestrian oriented, then we would work with you to flesh out those.
But if we had straight zoning, we would not see those plans and have that opportunity. So I think Mr. Bingston really, he hit the nail on the head with about everything that was said. This is to develop an innovative and imaginative approach, and it is based on planning. So I can imagine that there are people in the community who design and do development as such that wouldn't be as enthusiastic because they haven't been part of the planning process. So I think to really understand this draft, you would have had to have done what we've done for several years now, which is look at these projects and realize that we're butting heads and that they're walls to an effective planning process in a community, which is different than wanting to build a particular thing on a site that's zoned a particular purpose. That's not our objective. So to me, this matches basically what we have been asking to do, which I'm pleased to see it in a concrete form that could be doable.
Why I brought that up is that if somebody developed a site plan and put $20,000 or $30,000 into a plan, and we said, no, we want the pumps in the back, it's wasted money, so.
Well, I think perhaps if they know that there'll be a review process and that we have, specific goals in mind in terms of walkability, pedestrian-friendly sites, neighborhood balance, that they would take those things into consideration when they.
And I think what we've
Do
learned
that.
is that the staff works very closely with them before we get that plan. And so there's the opportunity. They are in touch with the comprehensive plan all the time. And so I have faith that that's the proper way for it to develop. If there weren't that staff interaction, I would agree with you, but I think there is a lot of it, and it's very, we've heard many compliments from builders who have said they worked well with the staff and they were told what they needed to know.
That said, I appreciate Mr. Andrews' phrasing of the pedestrian-friendly language, and while I don't necessarily want to make it a part of the motion, I think that we've talked about this for some years, and the staff knows that this commission, I've not heard any demurrals from that we are in favor of that kind of thing. So if the staff wanted to add language that would suggest favor being given to pedestrian-friendly site plans, I'd have no problem with that.
What we will do, and it'll be part of future study sessions and things like that, what if you go, and that's why I put the emphasis on page 14, because that's what you asked for, and that's what you were given, perhaps to be flushed out further. But it says the site development plan shall be evaluated on the basis of the development criteria for the comprehensive plan land use category in which the subject property is located. So if you have a site plan and it's in an area designated for neighborhood center, we're going to pull out that development criteria for what development should have in a neighborhood center. As Ms. Jackson alluded to, we're going to meet with the applicant and say, here's what the comprehensive plan says about development in a neighborhood center, as they develop their site plan, to take that into account. And then when we get an application that comes before you, we're going to write our report and evaluate from our perspective how the site plan addresses those points. And then what this is saying is that when you review a development plan, you're going to evaluate it on the basis of how well it conforms with those development criteria. So what it will require us to do, if this moves forward and it's adopted, is that we will work with you to make sure there's a good working knowledge of what those criteria are, and if we need to flesh them out in more detail, we will do that. But this is step one, to establish what the criteria you want to use to review a site plan, and that's
Mr.
very
Boxer.
important.
I was just looking to see, I may have misheard you. I thought you said that the next planning commission meeting was going to be July 18th.
July 18th.
I think it's the 20th, Dean.
Well, the 4th of July is a Tuesday.
Right.
And I was adding 14 days to that to come up with 18, and the Board of Zoning Appeals is meeting on the 20th, I think.
18th.
Okay, then I'm ready to make a motion.
That happens to me
I
all
just
the
want to
time.
be sure I said the right
It's the right day.
So our suggestion would be to postpone this to the July 18th.
Okay.
Continue the public hearing on that date.
I did preface that with, I might be wrong, so.
That's always just what put in there.
Or not here.
Mr. Chairman?
Yes, sir.
I'd like to move that we postpone Z17-5 until the July 18th meeting to allow and encourage feedback on the proposed amendment to the Salina zoning ordinance.
Second.
It's been moved and seconded to move application Z17-5 to our July 18th meeting to allow for further input from the community and further decisions. Any discussion?
I don't know if this needs to be an amendment, but I think that the comment should be made in the notes that the commission, from all appearances, seemed to favor the language that was there, and grant its approval as written presently. I guess I might ask administratively, Mr. Bankston, is that necessarily an amendment that you would make?
I would want to be sure that, appreciate that sentiment, but we don't want to have any indication of any predetermination until you have fully heard all public input
Got it.
on the draft. So-
That's why I'm glad I did make an amendment.
I wasn't going to let you do it anyway.
That's good. Because I'm
glad
we rely on each other up here.
We do. We have worked very closely together, and this is an example of that. So I'm very, very pleased to see this. Okay, any other discussion? If not, all those in favor, aye, please.
Aye.
Any opposed? Motion carries. Now, shall we return to item number 3.1?
At your discretion, we can move item 3.1 back on to your agenda, because we do have a representative here for that.
Then we shall do that. Application CU 11-7B, filed by Ein Street Tattoo, requesting an amendment of a conditional use permit. This address is 112 to 125 East Iron Avenue.
And I can't remember how many of you commissioners were involved in the what I'll call round one and round two of this, but the first determination was essentially we did not list tattoo parlors anywhere as an approved use within the city limits, and the Planning Commission looked at a text amendment to allow tattoo and body piercing studios as a conditional use in our commercial districts. And so having that text amendment get finalized, there was a conditional use permit process to establish the Iron Street Tattoo operation in tenant space 111 East Iron, and it was a relatively modest space. And as you can see, being an item of first impression and being an occupation that is heavily regulated by the state and the Board of Cosmetology, we had some fairly detailed conditions of approval on the initial conditional use permit, which are highlighted on page 2 and 3 of your report. And item 10 was that no portion of the tattoo parlor body piercing studio may expand beyond the subject tenant space without an amendment of the conditional use permit. Business was good. There was overcrowding, and so they expanded in 2012 into the next door tenant space at 113 East Iron. And so again, that was approved with the condition that any further expansions would involve public input and an amended conditional use permit. So we are now looking at moving into the next tenant space at 115. The plan is to cut a hole in the wall between 113 and 115, and we would want to get confirmation from the applicant whether it's solely for additional studio space or where there will be additional waiting area. But we found, or they found in our inspections, we found that 700 square foot initial tenant space made the waiting area a little tight, made everything tight, so they essentially doubled, and now they're looking to move into the space that most recently had the Beleza Salon. And so immediately to the east of this is Salina Vapes, and to the east of that, I believe, is still a coffee roasting business. Is that correct, John?
That's correct, yes.
Okay, so the role in your case is to evaluate the proposed expanded use, determine whether expanding the tattoo parlor in this location would be compatible with surrounding uses. The public hearing process allows you to receive public input and establish appropriate conditions of approval. And I think you're familiar with that from the original criteria, and from a public impact or perception, thing, the noticeability of the tattoo parlor may be partially a function of the wall and window signage, but it's also been a function of the number of individuals gathering on the sidewalk in front of the business. So what we would report to you is that the only public feedback we have received is just expressing concern about the number of people gathering and smoking on the public sidewalk in front of the premises. I went back and reviewed the minutes from 2012, and there was some discussion from the tattoo studio operator that they could control employees, but they couldn't necessarily control, customers, potential customers, and there was some discussion about creating a smoking area for employees in the rear, but we just wanted to clarify that obviously there's a city ordinance that prohibits indoor smoking, which means you have to go outdoors to smoke, and because of the nature of this business, to go outside means going out onto the public sidewalk. And so there is no general prohibition on standing on the sidewalk and smoking or gathering on a sidewalk, but that is the number one feedback that we heard. So I think that was the feedback you received from Mr. Hammond, John.
That's correct. There is a neighbor to the south who operates an office there, and he did comment that the existence of people just lounging or being on the outside of the building, and felt that was a negative for the general area, but that was his opinion.
Is that the case with like Salina Vapes or places that actually sell product like that?
We haven't received
Or
that
tobacco
feedback
products.
or comment. Most of the feedback we've heard relates to either customers or employees of this establishment or a gathering in front of there. And if we would also note that we have a new ice cream store that is open just to the west of this. They have put benches out on the sidewalk, and that is something we have a process for that, that business operators can get permission through the Downtown Design Review Board to put furniture out on the sidewalks that either moves in or out or is out there on a semi-permanent basis, as long as we have a clear path. And we don't know if that is a solution or an improvement in your eyes, but you could either recommend, require, or suggest that there be some sort of bench or some place to sit out in front. But we are basically saying that if you would want to act on and approve this expansion, that we carry over the same conditions that have applied consistently, and we just wanted to bring to your attention that there's, smoking outside is a function of the fact that you can't smoke indoors. So with that, the main thing that we would want clarification from the applicant for is just to clarify, A, is there going to be a hole cut in the wall between 113 and 115, and is the additional space going to be used for both waiting area and shop space, or just for one or the other exclusively? So with that, we'd be open to any questions that you have, and then we would want to hear from the applicant to clarify those things.
I guess my question still revolves around the fact that we don't have the policy for smoking and loitering and those sorts of things. So shouldn't those things be controlled from a lease aspect from the owner of the property?
Mr. Ravenkamp could address that, yes. The operator of the store could require his employees to create an area in the back, or the owner, Mr. Ravenkamp, could create an area on the north side John, do we have the kind of floor plan on there? So what you have here is that this is kind of, I call a utility tunnel or whatever. There's like a passageway back here that connects all the way back through. So these tenant spaces don't open directly out onto the parking lot. There's a utility tunnel here. So it's not like you can walk out a back door to there. And so it's not a direct opening to the outside.
Well, I don't want to ban them to the trash dumpster anyway, because they smoke. I'm not saying that, but I do drive by there all the time because my office is around the corner now, and there are often a lot of people there, and I wave. But there are a lot of people there, so I can understand there would be a complaint about that. Questions?
I was going to make an observation. Is smoking limited outside of this building in any way, shape, or form, other than distance from the door?
Well, there's a 10-foot
Right.
radius from the public entrance. You have
Right.
to stay outside of that 10-foot radius to the public entrance in. So
Do we have it, and I think you're right, I don't think we have any ordinances regarding lines and people standing in line at the Stiefel Theater or other places where people gather waiting for an event to begin. Those lines typically move a little differently, but I'm just trying to see if we have, and I don't think we do.
I don't think so. What about, like, for example, Martinelli's, where there will be outdoor dining now? In Salina, if you choose outdoor dining, can you smoke there? No? Because it's encompassed in the actual restaurant space.
no, it could, if it is far enough away from an entrance, you could conceivably have it there. It's going to be at the discretion of the owner, but actually when that was enacted, we worked with a number, primarily bars, not restaurants, but we had a number that we worked with that we created what we would call smoking patios. And so there were a number of drinking establishments in town where we created outdoor smoking areas because they couldn't smoke indoors. But there would still be, if there's a door that connects the outdoor dining space with the main entrance, there would still be a circumference there where you couldn't smoke within that area. But that would be up to the business owner whether they want to allow it or disallow it. But
So
there
is-
is no prohibition in smoking on a public sidewalk.
Is the 10-foot radius, is that a city ordinance or just
It is
a
in the city
building?
ordinance
Oh,
that
okay.
you, and I don't always recall, my recollection is that there's tape out
Right,
in
yes.
the
In the front
entrance
also,
into the
yeah.
entrance that you are not allowed to smoke inside that taped area. So
Well,
And also, how busy is that alleyway?
the,
they stand
you're
there?
you're talking about this internal alleyway, or I hope you're
Yes.
not talking about this alleyway.
I was talking about that one
Yeah, that one.
Okay.
to the west.
That, yeah, if maybe you, I don't know if you were here for the public hearing we had about the applicant that wanted to put steps that extended out into that
with the pole.
Oh, that's
alley.
right.
And so it is used by vehicle traffic, but not at a high volume. It's used more by pedestrian traffic, but it is open to vehicular traffic. There's this curve right here where you're coming around, and it's awful hard to make the curve around and do the U-turn. So most people come down this way and go out this way because I've tested it, and even in a small vehicle, it's really hard to do that. And if you have a pickup or some other vehicle, it's almost impossible. So what you see occur is somebody's parking here, they come out, and they exit out this way. But the Strombergs that own this building didn't really, they have an entrance right here, a tenant entrance, and they didn't really want the smokers or others to congregate in the alley. From their perspective, it was better that they be here than here. But
I'm
I
sure.
don't.
Any other questions before we hear from the applicant? Mr. Thornhill, I presume. Are you Mr. Thornhill? Are you the applicant?
I'm a
Oh,
representative.
one of them, okay.
Yeah.
Then state your name, please, and your address.
Spencer Foster. Do you want my home address or the
Whatever you'd like.
113 East Iron? Do you have any questions for me?
Well,
I
actually
believe
have
we
a
had some
comment.
specific questions
Our specific
first.
question is, if you move into 115, would you be punching a hole in the wall between 113 and 115, or is there already an opening there? And then I just wanted to clarify that the additional space, whether it would be used for studio space or whether you're expanding your waiting area, or what the additional space would be primarily used for.
We have there's already a hole through, and we've talked to the city or the building inspector, and it's all been okayed. We're going to be tattooing and piercing over there, and we're going to make sure the window's blocked off so no one's able to see from the street inside. We're going to keep the waiting we have, but we have 6 guys now. We started with 2, and we've expanded quite a bit, so we just need more room for procedures and stuff like that. I'll actually, being the piercer, I'll have a private room. Instead of having to go into the back and put up curtains, I'll have my own room with a door that shuts and everything.
And that'll be in the 115?
Yes, sir.
Yeah.
At the 115.
Do you expect more traffic?
No, I mean, we're just expanding for our own sake, so we're not so crowded. To make a comment on the smoking, there's only 2 of us that smoke, me being one. The other guys have all quit, so a lot of times it's customers. And here recently, we have a bench outside that was approved. A lot of the ice cream people are actually congregating in front of our business now because we have a bench also. So
That's right.
just to make a comment on that.
Oh, thank you. I appreciate that comment, actually.
But yeah, we try to keep people from smoking around the doors and stuff like that.
Any other comments that you
I
have?
don't have it. Sorry for being late.
That's
Sorry to
okay.
keep you guys.
We just
Sorry.
proceeded. Something else.
Just, I'm trying to recall, is it state regulation that the tattooing is out of sight, or is it just
I think that
city
was just the
regulation?
city.
Yeah.
But yeah, the owner, Travis Thornhill, he'll be tattooing in the front, which it has a window there, but we plan on blocking it off so no one's able to see in.
Yeah.
Per the request.
Well, in the many tattooing sessions I've been to,
We'd love for people to see. I mean,
Yeah.
I think a couple years ago, the Arts and Humanity, they actually asked if we could tattoo up front so people could see for art,
Right.
but we couldn't.
Well, my observation was that in Omaha, where I observed another one, that was specifically that it was a private space.
Yeah.
So I didn't know whether it was
Yeah,
required or not.
Travis, the owner, he tattooed out in New Jersey and on the boardwalk, and I mean, they tattooed right at the window. I mean, it was a lot. He said people would come up and watch, and it was actually, entertaining for a lot of people.
Any other questions for the
I just
applicant?
would want to point out that, again, there's things that are regulated by the State Board of Cosmetology, and then in our very initial inspection when this first opened, we have to commend Mr. Thornhill that he has been very cognizant of the conditions of approval and very careful and has carefully observed all the conditions. It's been our observation when we went over at the initial opening and we inspected against all these different conditions, and every one of them was adhered to at our initial inspection. So they have a good track record.
Okay.
Thank you very much.
Thank you.
So seeing no public that I think are likely to comment, I would go ahead and move to approve application CU 11-7B with the qualifications, the 12 qualifications as listed under the staff recommendation.
Second?
It's been moved and seconded to approve application CU 11-7B with the 12 recommendations by staff. Any other discussion? If not, all those in favor vote aye, please.
Aye.
Any opposed?
Aye.
One opposed. Motion carries.
So the reason it was important for us to know about whether there was an existing opening or not is that essentially if the opening is already there, then it means the space can just be moved into without any building permits or physical modifications. So we'll be sending out a letter that basically says you're free to move into 115, and since the opening's already there, you don't need any permits or anything to move in. And thank you for coming.
Our next item is an administrative item, number 4.1, which is application Z89-6D, which is filed by Robo Construction, requesting approval of a final site development plan for a multi-tenant retail building outside the Walmart parking lot in a planned C3 district. Addressed as 2950 South 9th Street.
Thank you, Mr. Chairman. John, if we can start with the aerial map, I think that'll be good to help us establish some of the background here. So the property that we're talking about is near the corner, the southeast corner of the existing Walmart parking lot. And the background for this whole property, this Walmart property, starts in 1989 when Walmart proposed to build the original Walmart store at this location. At the time, there wasn't any development this far south along 9th Street and down to Schilling. And so it was somewhat controversial, and so the Planning Commission ended up approving, similar to what happened with the Popeyes here just recently, instead of a C3 zoning district, they approved a PC3 zoning district. And so that planned element is why we're here today. So in 1989, the PC3 district was approved for Walmart, and then in 1993, to the north of this, is the First Bank Kansas property, and that also was rezoned from A1 to PC5 at the time, as the bank acquired a site owned by EarthCare at the time. And so they developed that site, and then in 1989, when Walmart became a super Walmart, as we know it today, they were looking to expand, and there was a joint application filed by Walmart and First Bank, in which there was additional EarthCare land that was brought into it, and the whole thing was zoned to PC3, and a detention pond, a shared detention pond, was added as part of that process. That is designed to hold and detain water for the entire development that we have out there today. And so what we're dealing with today is the application for a redevelopment of the corner portion of the parking lot for a tenant space that would have 2 tenants. And the applicant, Robo Construction, has filed the application on behalf of the owner, which is EMD Leavenworth LLC. In the staff report packet on page 6 and for the first half of page 7, I've lined out the bulk regulation requirements for the site and noted that from a bulk standpoint, the proposed development meets all of their criteria. And so what we'll do is we'll look at the site-specific elements that we typically review when we're looking at a proposed development in a planned district. And so to start with the building orientation, the building faces 9th Street, so this is actually the front door. And again, there's going to be 2 tenant spaces, one on the north half, one on the south half. For right now, it looks like a barbershop / salon for hairstyling, and then also a retail space for Cox Communications. And so in the front facade, what we have is we have a kind of a split facade where the elevation changes here. You can see the different elevation drawings here. And the bottom 3 feet plus the columns where you have the edge of the building here, the edge of the building here, and then a facade change where this portion here sits out a little further, like 3 feet further than this tenant space here. So these would be the 2 tenant spaces as you're looking at it from the east looking west. So you have masonry along the bottom, and then masonry on these columns here, and then you have a glass front here, and then you have an ephes with a cornice on the top. So that's kind of what we're looking at when we look at the elevation drawings. One question we have that we're not really clear on, and we'll need the applicant to help give us some specific guidance on and some information, is what is the masonry product? Is it brick? Is it stone? What is it? Is it kind of a split-face block? And then what are the colors of both the masonry product and the proposed ephes, so that you can have some information on that when you're making your decision. Looking at the traffic and circulation, if we go to the site plan, John, we're not looking to change the traffic or circulation of the Walmart lot. Currently today, there is angle parking that goes all the way to the end here, all the way to the end here, and there's these islands here virtually match the islands that are here today in roughly these locations. So if you take that island there and move it down, that's kind of what you're seeing. So there's this one-way or these driving aisles back and forth through here, and that's going to remain unchanged. The way the proposed property is accessed is through an access easement that runs across Walmart's property and then down to Schilling. So that's how the property is accessed. We're not changing any of the access points along 9th Street or the access points along Schilling. The parking that's being proposed, they do have 31 off-street parking spaces. And what we'll need is some information on how much retail area is being proposed and how many chairs or salon chairs or stations are being proposed for the salon, because that's how we figure out the required parking. And those equations are one parking space for every 250 square feet of retail area and 2 parking spaces for every hair salon station. And so that's another thing that we'll be asking of the applicant, is if they have information specific to that, so we can calculate the exact required amount of parking compared to the proposed 31 off-street parking spaces. Additionally, and it doesn't show up really well here on the aerial photo, but the City of Salina parking regulations require a parking depth of at least 19 feet for your stalls, and then a two-way driving aisle of at least 24 feet. And so what that comes to is 19, 24, 19. That means you have to have 63 feet total from one end of your parking stall to the other, and currently we don't meet that requirement. Now, what we do have is we have extra wide sidewalks around the building that may help with meeting those design criteria. So is this 13 feet? I'm going off memory. I can't. Can you tell by looking at that, John? 13.6. Yeah. So we have a little over 13 feet there. What we require is at least 4 foot open walking area for a sidewalk, and we do allow for up to 2 feet of a parking stall adjacent to a sidewalk to overhang. So what that means is, as long as we have 6 feet here, we could count 2 feet of overhang for that parking stall along the sidewalk here and along the sidewalk here. And I think this south one is 8, so both of them, or 7. So both of them are wide enough where we could have up to 2 feet overhang counting here, and then shifting it so that we have 19 feet along both the south and east parking stall rows. So those would be simple fixes to address that, but that's something that the applicant would need to commit to. Drainage, as I mentioned, there is a shared drainage pond northeast of the Walmart. You can't see here, but it'd be roughly in this area up here if you were to scale that out. And so there is drainage that the off-site drainage will need to be piped to or directed to. Signage, the applicant plans on having some wall signs according to the elevations. We don't have specific dimensions, but they are noted here in text that there will be some wall signage for the proposed tenants. What staff would need is we would need exact proposed sign area and a building permit application in order to approve any signage for that. And we also need information on what kind of poles or ground signs might be being proposed for this, for you guys to consider when you're looking at this. So that information we would ask that the applicant also provide when he comes up to speak on this application. Landscaping, if we got a landscaping plan, John. So what we require is, based on a formula, a certain amount of front yard landscaping area based on the size and dimensions of the lot. So for this particular application, the site is required to have 2,093 square feet of front yard landscaping. Front yard landscaping is landscaping in the front 25 feet of the property. So going from the property line, measuring back 25 feet, that's how much landscaping area is required on both frontages here. And the applicant is actually proposing 2,095, so they do meet those area requirements. In addition to the area requirements, they are required to provide what we call parking lot screening, which is shrubs or berms along the frontages of the parking stalls, and then also tree units, a number of tree units. And a tree unit is required, one for every 500 square feet of required landscape area. So in this case, we're looking at 4 tree units. So we do count those parking lot screening shrubs towards the required amount of front yard tree units, but then you only get credit for up to 1/3. So in this case, you get 1 tree unit for the shrubs that are being provided, and so we're still needing 3 tree units. They do have some islands, peninsulas that have trees in them, which is what we need, which is what we require. We require that they have at least 60% living material. So everything that you see in the islands looks sufficient to us. What needs to still be addressed is the addition of at least 3 tree units in the front yard setback area here. And so that could be a shade tree, or which we have a recommended tree list that has those categories, those lists of shade trees that do well with our climate and soil types, or 3 ornamentals, those trees that do well with, again, our climate and soil types. So we're looking at additional 3 tree units in the front area. The area itself looks sufficient, so it would be a matter of adding those trees. There is a trash enclosure that is proposed on the south of the building here. What we don't have is elevation drawings showing the material or describing the material of that screening substance, and we would request those elevation drawings or information of what that material will be and how tall it will be. Parking, loading, and unloading. This particular facility would be required to have 1 loading, unloading area with dimensions of 10 feet wide and 25 feet in depth as their minimums, and that's something that also needs to be addressed by the applicant. And so with this being an administrative item, you have the discretion to look at what's being proposed and either approve or disapprove the particular site plan. You could approve it with conditions, or if you think that there's just a little bit too much here that's still lacking and you'd rather have some items fixed and brought back to you, you could postpone approving it or making any kind of specific approval until you see an adjusted or revised site plan. In this particular case, there are a number of things that seem to be rather minor that staff feels could be pretty easily fixed, but we would like to hear from the applicant on, and I've lined those out on page 10. So one is details about the specific masonry materials that are being proposed, as well as the masonry color and stucco color of those elevations. And then more specific information in terms of the floor plan of how the building will be broken out and how much retail area there will be and how many salon chairs there will be for the barbershop / beauty salon. And then number 3, the proposed location of the 10-foot by 25-foot loading and unloading area. Where is that going to be proposed and how will that impact the site plan? Elevation drawings are needed of the proposed trash enclosure, and then information about any proposed ground or pole signs would also be needed for our comfort level. Now, if these items are all addressed to your satisfaction, we would recommend that you would approve the site plan, and we have lined out a number of conditions to meet some of the deficiencies that I mentioned as we went through our our site plan analysis. And those are listed on page 11, but they're redundant from what we've already touched upon. But if you have any questions, I certainly would love to try to answer any of them.
Yes, there is a frontage road in that location. Does that be vacated then?
The site currently has access directly onto Schilling, and then up to the north, it has direct access to 9th Street, but there isn't a specific frontage road other than the driving aisle on Walmart's.
The driving
park, yeah.
driving aisle is a better term than
Sure,
frontage
okay.
road. So that's going to be taken out.
What you're going to see, if we can go to site plan, John. Is there one there? Thank you very much. So this here is currently the driving aisle that I think you're referring to,
Yes.
that goes all the way to the north to where it intersects with 9th. The property is accessed from 9th Street. This will remain the same. It will change once we get to this site where the driving aisle will kind of have to turn a little bit to this driving aisle where all the stalls are accessed for the proposed development site. This development, or the driving aisle on the south will just go straight in through. There won't be any change. If you can see it, because you have a row of stalls along the south end, that will remain consistent. The big change is along the east, because you have a driving aisle there that's going to run into this kind of parking lot island or peninsula, which we will have landscaping. So you'll have to kind of turn and either go south, or if you want to enter the site, you can just kind of curve around. I don't think it's going to be a major circular issue. It is a little bit of a change to some point, though.
Mr. Hayes,
It's not a public road. It's owned by Walmart, so there isn't any need to vacate it per se.
what is in the 3 islands that we see there? That's on the Walmart parking lot property?
This island here, this island here, this island here.
What's in there now?
Well, these two are located here, and I believe they have trees and maybe some shrubs.
'Cause I don't remember ever seeing a tree in that parking lot.
Yeah, these are the current islands here.
Those islands be coming out.
These islands are the ones
Those
that are
other
shifting.
ones don't exist.
Yeah.
Right,
These
but I'm
islands-
saying in the shift, will they have to meet new requirements? That's my question. Are they going to have to put in landscaping
We are
that's
going
appropriate?
to require Walmart to replace the trees that, if you have your pointer, those, if they will construct new islands, they will have to put trees in those islands to replace the ones that are being removed.
So these islands will move back here, and then they'll have to be replicated, where they'll have to have a tree and shrubs put in there.
I was looking for more than replicated is what I meant.
Okay.
Because I don't remember any trees. But I'm going to drive out there now and look again.
Okay.
Because if they're trees, they're little shrubby trees. That's what I'm saying. Are the standards, obviously the standards were not in place when that Walmart parking lot was built that are in place now. Because you're going to have this corner island that's going to look like an oasis in comparison to the rest of this concrete asphalt blight, right? So at least if the 3 islands got somehow landscaped a little better, it'd be a softer transition to this corner.
We are probably due for that again, but just for point of reference, the landscaping at Walmart has been replaced at least 5 times in my experience where it had to be replaced. And so one of the challenges out there is that the trees don't get an opportunity to mature like they do on other sites because they have to constantly be replaced.
Mm-hmm.
And so that will be part of but that is not the obligation of this
No,
developer. That's something
Yeah,
that we
I
would
just
deal with independently with Walmart.
In contrast, there will be a huge contrast, which I'm glad that we don't have someone requesting no landscaping because there's none around them. So
But
that's a good thing.
The original Walmart was done in 1989. The city's landscaping regulations were adopted in 1994. So you are correct that there was not the same standards in place in 1989 as there are currently.
Why are you saying they have to keep replacing the landscaping?
because prior to 1994, the landscaping was done on a case-by-case basis through the site plan. So the Planning Commission and City Commission required Walmart to submit a landscape plan, even though we didn't have a landscape ordinance, and that was required through the planned commercial district site plan. So there is a copy of the landscape plan for Walmart in your packet, and so because that predated the landscaping regulations, that's enforced as a condition of the site plan approval, not from the landscaping regulations, because there were not any at the time in 1989.
Well, looking at that planning, sorry, one more thing. Looking at that, I did look at the plan for Walmart's plantings, and that would make me want to stay in the planning process for the future, because that's not a landscape plan, really. Okay.
No, in relationship to planting a shade tree, and I'm all for those kinds of things, but you're putting a shade tree in 20 by 20 square, surrounded by asphalt. That's, unless you have an arborist who's going to spend 2 or 3 weeks a season taking care of that tree, it's not going to thrive. Its roots may go a long ways, but it's a long ways to that ditch out there and on 9th Street to get nutrients and water. And I'm not suggesting they shouldn't. I'm just saying that's why they die all the time.
Well, I think
it's not a surprise to me.
there are probably more appropriate plantings, and that's my question.
I agree with that too.
If that, when they're replanted around there, if they are something that's more appropriate and still decorative and still scaled to the site, because there's got to be something more than a half-dead tree.
It's probably,
Cactus.
they probably
grasses.
Palm tree.
pile snow filled with road salt
sure,
in there,
sure.
and that's what kills them. So if they didn't pile the salt there, the tree would thrive.
Well, yeah, because it's a huge, huge expanse of paving with teeny little trees dotted in the middle of it.
So this
But
may
anyway,
have
we're
been,
not talking about Walmart.
well,
so-
but this may have been answered, but if Walmart is replacing that, are they required to replace it only to the 1989
That's what I
standards?
asked.
Yes, they have to maintain the same level that was approved in 1989. They submitted a landscape plan, and that's what we're enforcing.
I see.
We can't take the new requirements and apply them retroactively. We can apply what the Planning Commission required in 1989.
Even though they're moving the islands around.
Correct. We can ask them to replace anything that is removed or missing, but we can't impose new requirements on them.
Well, then, yeah, maybe we need to look at if it's all really there. Okay. Anyway, I got a little off the topic. Are there questions for staff besides about Walmart's parking lot landscaping plan? No? Are the applicants here? Would you like to address some of these questions? Your name, please, and address.
I don't really have any. Oh, Steve Roble, 7401 Lakewood.
Thank you.
All of the suggestions we intend to do, we don't see any objection with anything there. And in our purchase of the land, we're required to put those 2 islands in. There are trees out there about that big around. There are some, but we'll move the 2 to the west and redo those. Any other questions?
Yeah, I think that, did you want questions about the exterior facade?
Masonry, yeah.
I think the 5 recommendations, are those things we want clarification
Yeah.
on now?
So I have listed 5 questions or points of particular interest that we need to look at in our analysis of the site plan. And the first one is the details of the facade and the material and colors that we're dealing with. The drawing shows masonry product here in the darker colors that we see, and then an ephes in the lighter colors there. The question is, when you say masonry product, what specifically are you referring to or are you identifying? And then what are the colors of both of those types of materials that you're looking at?
Well, the brick that's shown on there will be a burgundy red color of some sort like that. And the stucco is going to be somewhat similar to what Walmart has. It'll be a brown look. There's no purple or green or anything like that on there.
And so the brick, is it a split face block? Is it?
No, it's a regular brick, house brick.
So you put the staccato board on the top part?
Well, it's going to be the stucco
Floor plan or
finish.
the site plan, we can't tell with the breakdown of the space.
Okay. And then if we can go to site plan, John. So on the site plan, we've got this facade change roughly here. So I'm presuming that the tenant spaces there's going to be a wall here between the two. Is this how the tenant spaces would be broken up?
Yeah, there's a wall between the two tenants. Is that what you're?
Yes. Is it going to be in this location is, I guess, the first question.
I don't think that Cox has got more of the space than what Great Clips has. So it's going to be pushed. The Cox area will be larger than the other one.
Mm-hmm. So
and that looks like that's in the middle.
Well, this is the north wall. Here's the south wall. And it looks like there's a facade change, which, looking at the elevation drawings where the facade change takes place, I'm presuming that's where the wall would be between the two tenant spaces.
So what do you, the building will have the drive-it stucco on all four sides of it.
Mm-hmm.
And the 3-foot brick all the way around the four sides of it.
Sure.
So the question is that in the case of a Great Clips, the required off-street parking for a Great Clips type facility is based on the number of chairs and operators that they have. And since this plan doesn't show us a layout and we're not sure about the square footage, in order for us to say that we're on the mark on parking, if we could get some idea of the 3,800 square feet, how much of it was going to Cox and how much of it was going to Great Clips, that would help us.
1,200 and 2,500. Cox has got the
Cox is
largest amount.
2,500. Cox is 2,500.
Yeah.
Still haven't said how many chairs.
Do you know?
It would be 6 to start with.
6 chairs.
So when you say to start with, there's potential for more chairs there?
So 22 required.
They've shown us 6 on the site plan. I don't honestly know if they've ever got.
Sir, if you will need to approach the mic, please.
Yeah. We're getting in directions from the Access Television folks about.
I'm sorry. I'm Phil Bundy. I'm from Wichita also, one of Steve's partners. And Great Clips is 1,200 square feet. Cox is 2,500 square feet. And the Great Clips plan that I've seen shows that they will have 6 chairs in the salon.
Okay.
But I think the question is, to start with, would make it sound as though there would be more. And in terms of parking, you can't add more parking.
I
Right.
understand. I don't anticipate that there would be any more, but the plan is 6. So if I understood correctly, there needed to be 2 stalls for every chair, in addition to the 4 per 1,000. So
So we got 20. So basically, what we're looking at is, from the information that the applicant's given us, we would be required to have 22 off-street parking spaces. They're providing 31. So they do have some room for some modifications and additional stations if it comes to that.
Thank you. Other questions?
Yes, do you have a landscape plan?
I'm sure we do. I don't have one. I don't have one with me, and I haven't seen one, but yeah, there will be one. I'm sure it is.
So what we have today,
It's in
yeah, what we do is we do have a landscape plan. The point of interest that staff has pointed out is that while it does have screening with shrubs and other low-lying vegetation, we are still required to have 3 additional tree units, which could be 3 shade trees, or it could be 9 ornamentals or a mixture thereof? Because a tree unit is a shade tree
Sure.
or 3 ornamental
Well,
trees.
I think we can assure you that although this may not be as much specifics as some of the people would like to see, that we will meet all the requirements, and we will have the number of shade trees, and all the landscaping plan will fit the requirements.
And so I think what staff's comfortable with if the planning commission is comfortable, staff's comfortable with working with the project designer to figure out where to put those 3 extra trees, because I don't think it'll be a big issue. It's just adding to what's already there.
In addition, I'd like to make the point that those 2 landscape islands that are going to be pushed further to the west, that currently are the Walmart ones, our agreement with Walmart is when we move those, that's our responsibility to re-landscape those landscape islands. So we'll make sure that those meet the new requirements rather than the older the older Walmart requirements as well.
Thank you.
And they'll be irrigated.
Absolutely.
Yeah.
So then the third question deals with the loading and unloading area. We do require a 10 by 25 foot stall loading unloading area for inventory, supplies, things of that nature, and didn't know if you had figured that out of how that would work with the site.
I don't really know that we've addressed that.
Both of these 2 particular tenants are not going to need quote-unquote unloading because they're both service industries or they're both service users. So if
Just
that's
take a parking spot that we designate? What is the requirement?
Potentially, if you had the dimensions, I don't see where specifically that might work, but because you do have surplus parking, if your designer could work to incorporate, maybe reduce some of the parking and incorporate a loading and unloading zone in one of those spaces or in a few of those spaces.
We can absolutely figure that out. We're just not sure where yet today, but we'll figure that out.
Yeah. Yeah, because you have surplus parking, so you could, do some converting of things, and just off my head, reducing the sidewalk here, maybe, so that you have a deeper stall here and having an unloading zone there or something like that. I don't know. That's just an idea off the top of my head.
We can absolutely figure that out.
Well, the stuff that's going to be delivered is going to be shampoo.
Right. I mean,
And they most generally drop it off at the front.
I think you're absolutely right, is that most things that we're going to get deliveries are going to be just UPS type stuff, that they'll just drop off 2 boxes and walk in the front door with them. So,
Won't be a big deal.
so it's not a big deal. But we'll figure it out if it's a requirement.
Mm-hmm.
Okay, I have a question. I guess this is for staff. If that's a requirement on this site, why is it that it wasn't included in the design to begin with?
I didn't design the site, so I
know,
can't
but
tell you
I mean,
that.
were they given specifications that said that?
Well, they have access to our zoning regulations, if that's what you're referring
That's
to.
that's my
Must have been
question.
an oversight on our architect's point, but we'll get there.
Because this kind of
Can
ties
we-
back to other discussions that we've had.
Can we even approve it then without?
We can, but again, it goes back to other discussions we've had about.
Just to clarify that in many cases, particularly of restaurants, and then the Chick-fil-A comes to mind and others, where what we have done in those cases, and particularly with restaurants, is that they don't necessarily designate a loading zone, but they use the parking lot area for doing that, and they provide us a letter that essentially that the deliveries will occur during non-business hours. So what you don't want is to have a delivery truck or something there's no place for it, so it's blocking parking stalls, or it's blocking people into parking stalls, or that type of thing. So the purpose of having a designated loading unloading area is just so you don't have delivery vehicles that are blocking an access aisle or blocking cars into a parking stall, that there's a separate designated place for them.
See, I feel comfortable letting that happen administratively, because as much as Dean talks about that we, whoever that collective we are, these guys, the owner of that property, doesn't want to have customers unable to park in front of their business because the truck's there. So I think it's a problem that's easily solved. It just needs to be done.
Yeah, I totally agree. It's just because I know what this will look like and I'm comfortable with it, but it's across the board I'm talking about. I'm not as comfortable with every single project and everybody's concepts. I know what this will look like.
Yeah, and I think that's from staff, as we present this to you, that's what we're trying to say is these are where the site plan currently meets all their criteria. These are the areas where we see that there's still some information needed, and how comfortable are you with us working with the applicant to address those issues?
Yeah.
And we've aligned what those issues are out in the staff report, as well as try to construct some conditions of approval if you feel like it's a pretty good site plan that just needs some minor tweaking, so to speak.
And I would I would agree with Commissioner Boxa, and I think I'm comfortable with that as well. It might be mentioned, it seems to me logically, those buildings are going to be there for a while, and it may not necessarily be a Great Clips in 20 years. It might not be Cox
Thought
in
of
20
the same
years.
thing.
So
Yeah.
that's the reason for those
It
regulations.
might be reused,
Yeah. So
repurposed.
So I think that leaves us with just two items. If you have any specific guidance or thoughts on the proposed trash enclosure, and then also ground signs or pole signs of what you would be proposing for the tenants there at the location.
Address what you think on the trash.
The trash is going to be a 8-ite block on the three sides and then the gate in the front. As far as the signs, we would probably have to refer to our tenants to get them to approve where they feel the signs should be. But we've always done the signs totally separate from any other part of the building. I mean, we submit a signage plan.
Well, typically, those just be front signage, like you show on the, like Cox and Great
We
Clips, and
approve
so
that
there
as
would be a
building.
pole sign. I can't imagine.
the square footage.
I can't imagine where you put a pole sign out there.
We'd prefer actually not
Right,
to.
right.
So what we typically do for planned districts, or especially C3 districts, is we have a limitation on pole signs or ground signs, and then we use the district regulations to regulate the wall signs. And any proposed signs would require a sign permit, a separate sign permit, is separate from the building permit as you come in and get a building permit for the proposed development. And so what we have on page 11, number 6, is a condition that I want to see how everybody feels about, both the applicant and the commission, that says signage shall be limited to one freestanding sign not exceeding 120 square feet in area and 30 feet in height, and wall signs in accordance with the C3 sign regulations. And that's pretty typical. That's
From our standpoint,
boilerplate.
we're fine with that.
Okay. That's boilerplate for what we typically do for our planned districts.
Yeah, and that same vein seems logical and within boundaries for here.
Okay, so that would address everything that staff would have noted during our review and analysis of the plan.
Any other questions?
Can we go back to the proposed landscape plan? And I see there's plants listed on the right in very fine print, and was wondering, is that what is proposed? And then does it have to meet a required list, or is it a recommended list that we have?
We have what we call the City of Salina's recommended planting list. It's a xeriscape planting list, which was built with feedback from various agencies, both local and some more regional. The list consists of both ground covers, shrubs, ornamental trees, shade trees, and I did check the list, and everything that's listed there is from that list, if that's
good.
one of your questions.
Great, thank you.
Any other questions for the applicants? Thank you, gentlemen. Any other questions for staff? No? Comments? Well, you have some work to do still.
We can do it.
I'm sure you can. You always do. I have complete confidence in you. You just want innovative, imaginative planning. A motion?
Yeah, I would move that we approve application Z89-6D with the requested recommendations from the staff, numbers 1 through 9 on page 11.
I would second that.
Okay, wait.
Excuse me, and yes, and with their receiving additional information, items 1 through 5 on the previous page.
Second.
It's been moved and seconded to approve application number Z89-6D, along with the 5 staff recommendations, as well as the 9 requirements listed on page 11. Any discussion? If not, all those in favor vote aye, please.
Aye.
Any opposed? Motion carries.
Don't know if it makes any difference with the record, but I show Commissioner Story first seconded that. But
That's okay. Give him the variety. I don't need that.
Our notes reflect that Story was first.
Wally so rarely does that we should let him.
What did you say?
I said you so rarely second things.
I know.
That we should
I
let,
felt wasn't
let you
necessary.
do that.
Neither here nor there, but why would Walmart be interested in giving up parking spaces?
This is a trend around the country, and it's actually occurred on the Sam's Club site on the other side. One of the battles that the planning staff had and planning staffs around the country is that Walmart designs and plans their parking lots for the Friday after Thanksgiving, and the rest of the time they have large amounts of paving and asphalt that don't get used. And so a lot of the people in Walmart's real estate division realized that they had excessively large parking lots on many of their sites, and those parking lots have potentially higher value than as parking lots. So they have, what was done here is that we did a lot split and split off this as an outlot. We also did one on the other side of the street in front of Sam's Club. It has nothing has occurred there, but our ratio for parking is 4 spaces per 1,000 square feet of retail. Walmart's requirement is anywhere from 5 to 5.5 spaces per 1,000 square feet. And so most Walmarts and Sam's Clubs have parking spaces that never get parked in during the course of a year. And so they have gone around and realized that internally, and so their real estate division and says, hey, wait a minute, we've got these parking lot areas that nobody's using. They might have higher value if they were used for something besides surface parking. So that's the trend.
Is that the only chain that has that problem?
They're not the only chain, but I'll just say that Walmart has amongst the highest parking ratios internally of number of spaces they require per square foot of store compared to other chains. So you could have a Target of the same size as a Walmart, and Walmart will have a lot more parking spaces because of their internal requirements.
Which is why, as a marketing thing, they offer free parking spaces for itinerant truckers and campers.
And for campers. Well, they could probably do with some garages, probably, and condense that. But we don't have that policy, I guess, in effect. So, anything else on the agenda?
Under
Thank you,
other
gentlemen.
matters, there's just a couple things that we wanted to touch on. One, last night, the City Commission did not take any action on the temporary sign regulations and postponed it a week. And basically, it's narrowed down to 3 options they want on the table for them. Option number 1 is your original recommendation from March, which essentially the only exceptions would be for election signs and on-site real estate and garage sale signs. That's the most restrictive option. Option number 2 is the option that you just recommended that would allow for off-site advertising signs and on-site business signs for contractors and construction activity. But that they found to be completely complex, which it is, and potentially difficult to enforce and administer, which it is.
I
And
thought
then
they had sent it back, though, because of opposition to those things.
that they acknowledge that you did and staff did exactly what they asked, but when they got it back, they weren't so sure. So then the third option...
They should come to the planning table.
The third option they want in front of them, which will be laid out, is what
Or I should
is
go
the
to
most expansive, is it says, we're simply going to say you get 2 signs or 3 signs not exceeding this size, and we don't care what they say.
Which is where we're going.
So we'll see, but those will be the 3 options that will be, and so there's some are in the middle or wavering between the 2 ends, and so what we tried to do was what I call the hybrid, which is a combination of all those things, and they said, wow, this is really complex, and it is, and it is correct that what we can come up with that's legal is not very practical, and what makes the most sense to people, the Supreme Court has basically taken that tool away from us. It makes most sense to call a real estate sign a real estate sign and a garage sale sign a garage sale sign, but the decision that the U.S. Supreme Court case says you can call it a yard sign, but you can't call it any of those other things. So that will go back to them their next meeting. They also adopted an ethics policy last night that applies to themselves, but it also applies to all the advisory boards and commissions, and there'll be some follow-up on that where we might get the assistance of Mr. Bankston and Mr. Martin to kind of go over that. In your particular case, it doesn't really change much because your bylaws are stricter than what the City Commission had for themselves. So the new ethics policy is more in line with the Planning Commission bylaws. And so it clarifies some things, but it's not a substantial change, but it may require that each of the boards in Salina have bylaws that reflect that new ethics policy.
If I could, I was going to make a comment on the first one, but the second one bothers me or concerns me more. And my concern is not for this group, or it might be for the elected body as well, is that recusal is something that we want to avoid. And I'm afraid that we're opening this up to anytime anybody feels like they might be uncomfortable making a decision, that they can recuse themselves. And as a public person, or as a person sitting on this board, if I got the impression that someone recused themselves because voting for a particular item was difficult or uncomfortable, then I would suggest that that person resign. Recusals are not made because what's about to happen is uncomfortable. They're made because you are unable to vote freely because of some financial arrangement, for the most part, that keeps you from doing that. And I'm concerned. I am concerned that people are going to say, well, even if it looks like or feels like, or somebody else might look or feel or think that it's a conflict, that you are to recuse yourself. And that's going to spoil our form of government. There isn't a person who doesn't vote after hearing the facts without weighing in some of the things that they bring to the table. And so that's my rant on that, is I think that has a real possibility for we say, well, I don't feel very comfortable with this, I recuse myself. No, you can't. You in some cases got elected to do a job, and in some cases you volunteered to do it and do your job.
Well, Commissioner Box, I agree with your sentiments, but it seems to me like the bylaws are pretty clear. If you stand to benefit in any way, it is still up to the judgment of the commissioner or board member whether they are indeed in that place.
but if you-
I think I hear you, that if they're just uncomfortable, they
But it
should
says
resign and
if
not
there's an
take responsibility.
appearance of, read the entire, I agree,
yeah,
there's,
right.
there are specific amounts of money that you have to receive from someone over a period of time in order for that trigger to occur. But the way the wording is right now is if there's an appearance of. And I think that's very, I worry about that a lot more than the signs or anything else. So, anyway, that's what I had to say. Sorry.
Thank you,
In
Mr.
an
Bach.
ideal world, nobody that's on this board or that board should abstain because they think it's too controversial or it's too hard. There should be specific grounds to abstain or recuse yourselves. And we will go into that in more detail. And along those lines, we provided with you some information just for your reading enjoyment about the new trend of vertical greenhouses, some information about planning commissioner ethics that just reinforces what we talked, some information about fracking and drones, which are two technological changes that are in the news, and then some information about the benefits of trees as infrastructure. And I thought the one thing that was notable about that, it talked about trees being the only infrastructure that increases in value over its lifetime. So storm pipelines and sanitary sewer lines and streets generally degrade over their lifetime, but they, at least the position of the Society of Municipal Arborists is that trees increase in value over time and have benefits over time. So,
Especially native trees.
and those, that is
Get that in there, Dan.
an article just for your benefit. And then the third item is based on our experience today and discussions that we had this morning. We're going to introduce a third category of items on your agenda. And the third category is we are guilty sometimes of being over anxious to advertise hearings on text amendments because we want an opportunity to get feedback from you and an opportunity to get feedback for the public through the public hearing process. But what we're going to institute on our next matter for your discussion is we're going to have public hearing items. We're going to have what we're going to call preliminary discussion items, which are going to be public, open to the public, and we want public input. And then we'll have administrative items. And so our next subject of interest is indoor shooting ranges, which we do not presently list as an identified land use in the city limits. And we were going to initiate that through the discussions of that through a text amendment that we were discussing with a party. But what we're going to do instead is on your agenda for July 18th. We're going to give you some background information about indoor shooting ranges. We're going to invite people who are knowledgeable and who are interested in indoor shooting ranges, and we will have a general policy discussion, have some direction from you, some input from the public, and then use that. And so what we will try to do in the future is that we will, when we're in the format of having a text amendment, is that we will bring you a draft of a text amendment. We'll let you review it, and then if you are comfortable with that draft, we will initiate that, and that will start the 20-day public hearing process. And then what you'll have there is then you'll have a longer period of time built in from the time that you initiate the text amendment to when there's the statutory public hearing on it, there will be a longer lead time and review time, both for your review and for public review. But the challenge for us is that the state law requires that to do a text amendment, you publish notice of the public hearing in the Salina Journal, and it get published, and that has to occur at least 20 days before the hearing. There's not a requirement, because it is a text amendment of general application, there's not a requirement for individual notice. So I recall an example of a community, and we did that here. When I was first hired, we didn't have any floodplain regulations, and my job was to draft them and get them approved by FEMA. And we did not identify every single potential property owner in Salina and Saline County that just might be in the floodplain and say, we're doing this text amendment to have floodplain regulations, because they are of general application. And so there was a community where they adopted floodplain regulations, and a resident sued the city saying they didn't get notice ahead of the Planning Commission hearing, and the court said there's no obligation to provide individual owners with notice. Nonetheless, our internal policy is to try to get those things out to stakeholders and interested parties so that there can be input. So while there's no statutory requirement, it's an internal requirement. So what we're going to do then is, instead of having a statutory public hearing and trying to flesh out the elements of a text amendment, what we'll do is have a preliminary discussion, get feedback, get guidance, have members of the public be able to speak on it, but then we won't actually initiate a text amendment till you can see a draft and say, yes, we're ready to advertise this. So that's a pretty dramatic change, but we feel like using the preliminary discussion still allows for dialogue and communication, but doesn't put us under the obligation of the 20 days in the statutory hearing till you are ready for that. And that will also avoid the thing that we do too often, which is bringing you text amendments, the language of which has not been finalized till shortly before you get them or at the meeting. So.
And I imagine you use social media now, not just the Salina Journal, to.
That's something we discussed this morning as well. So the other thing of importance to note is that the city purchased some software that we're using in our building and code enforcement, but not in our planning, because it is not, that didn't live up to its promises in that. But we are now purchasing a new software package called Llama, and it is designed by and for planners, but also has building and code enforcement things. And so as we're also looking at this as we transition to that software, that will also have some changes, but that will be something that will occur over the next, I don't know, what do you think, Crystal, 6 months?
Oh, longer than that.
Okay. So
Realistic.
we'll be easing into it,
Shooting for late spring.
but we're preparing for it now. And so one of the things we're going to do, so if we have a case like tattoo parlors or vape shops or indoor shooting ranges, and we want to get input from you and we want to get input from the public, instead of requiring a text amendment in the formal process to do that, we're going to create a preliminary discussion item on your agenda so we can so we're not limited to a study session. We can have it in the open. We can have minutes. We can have people come and speak and express opinions. And so we're going to endeavor to introduce that.
The more ways to engage, the better.
So we appreciate your time, commitment this evening, and we'll see you on July 18th.
And don't forget, there's a farmer's market.
If you want
35
to come on the
minutes.
20th, you're welcome.
I would have thought I was being so smart.
They brought it from Ellsworth for me.
Happens to me every day.
Yeah, right. When I was working regular.